Welcome to the Deep Dive, your shortcut to becoming well-informed, where we cut through the noise and get straight to the most vital insights from the material you need to master. Today, we're taking a really critical plunge into the meticulous world of digital evidence. Our deep dive is titled, Exposing the Truth in the Digital Evidence. And this is especially for you if you're a student in the Dr. Sampak College of Business, maybe you're in management information systems, IT, or computer information systems focusing on computer forensics, or really any student or working professional who's interested in this fascinating, sometimes pretty high stakes world of digital investigations, then yeah, this deep dive is absolutely for you. Our mission today, to explore Chapter 14, Report Writing for High-Tech Investigations. It's from a really key textbook in the field, Guide to Computer Forensics and Investigations, 6th edition by Nelson and Stewart. We're going to look at just how crucial, clear, precise, and effective report writing is, not just for finding digital truth, but for actually uncovering and, presenting it in a way that really matters, especially in a legal context. Before we jump in, though, if you find this deep dive helpful, please take a moment to like, subscribe, follow, share, leave a comment. It genuinely helps us bring you more of these vital insights. Okay, so let's unpack this. We talk a lot about the technical side of digital forensics, the tools, the techniques, all that digging for evidence. But why are these reports so uniquely critical? In these high-tech investigations, it feels like the forensic work itself should be the main focus, but the report seems to carry so much weight.
That's a really fundamental point, and yeah, you've hit on a core challenge. Think of it like this. You could have groundbreaking digital evidence, absolutely solid stuff, but it's pretty much worthless in court if you can't translate it. Translate it into a language the legal system actually understands and, frankly, trusts. The report is that translation. It's where all that raw data becomes, actionable truth, something that can actually sway a judge or a jury. So these reports in computer forensics, they aren't just summaries. They're the formal communication of your findings, and they become critical, often legally binding documents. All that hard work, it can be totally undermined if you can't communicate clearly, precisely, and persuasively. And the courts, they have very specific requirements, really stringent ones for expert witness reports. Your report has to clearly state your expert opinion, and crucially the basis for that opinion, why you think what you think. You also have to include all the information you considered when you formed that opinion, any exhibits that back up your claims, and even the fees you were paid. This level of detail, it isn't just like good practice. It's a legal necessity. Ensures transparency, accountability. What's fascinating here is how attorneys then use these reports. They often tap into something called deposition banks, which are basically libraries of previous testimony, stuff given by expert witnesses before.
Ah, okay.
And it's not just historical record, it's strategic leverage. Attorneys use these banks to research, prepare. They want to know how an expert testified in the past, helps them anticipate questions, figure out strategies for trial. So every report you write today, it could be picked apart by opposing counsel tomorrow.
Wow.
Used to guess your arguments, maybe even challenge your credibility. So yeah, these reports aren't just static documents. They're active players in future legal battles.
That really puts a whole new spin on it. So the report is kind of like a projection of your expertise into the future. And I've heard that in many courts now, especially federal ones, PDF is the standard for electronic submissions. Is that right? And what's the big deal about that format specifically?
You're spot on. Yeah, in many courts today, particularly federal courts, documents go in electronically, and PDF portable document format is indeed the standard. And it's not just about convenience. It really speaks to the need for a standardized format, something unalterable that preserves the integrity of your findings.
Right.
It just underscores the formality, the precision that's required. Make sure what you submit is exactly what the court ends up seeing.
Okay, so given how critical these reports are, it sounds like we can't just, dive in blind and start typing. What's the strategic blueprint we need before we even touch the keyboard? What kind of thinking goes into crafting these reports effectively from the get-go?
Oh, absolutely not. Blindly writing is a recipe for trouble. Before you even write a single word, you need a clear strategy. One big advantage you have as the investigator is being able to clearly state your job mission or your goal right there in the report.
Oh, okay, define the scope up front.
Exactly. It sets the stage, defines the scope of your investigation. It immediately helps guide the reader. Tells everyone, look, this is what I was asked to do, and this is what I aim to find. Beyond that, there are two really critical pre-writing steps. First, identify your audience. Who are you talking to? And second, understand the precise purpose of the report.
Right.
Is it for an attorney? A judge? Law enforcement? Maybe a corporate client? Each one might need a slightly different emphasis, maybe a different level of technical detail. And what's the report for? Is it just to inform?
To support a legal argument.
Yeah.
To recommend more action. Knowing these things up front, that's going to significantly shape your whole writing approach. Make sure the message lands right.
And I guess getting that audience and purpose wrong could just completely derail the report's effectiveness, couldn't it? So knowing who you're talking to and why really changes everything. What are the common types of reports we see in digital investigations? How do they differ in their role? Sounds like it's not a one-size-fits-all deal.
You're right. It's definitely not. There are different formats, different types, each serving a specific role. First, we have examination plans. These are a bit unique because they're usually prepared by an attorney, not the forensic examiner directly.
Yeah, their purpose is to help you, the expert, anticipate the questions you'll face when you testify. They're kind of like a roadmap for your testimony, helping you get ready for what's coming. Then you've got verbal reports. These are often less structured, usually seen as preliminary. You use them when you need to quickly share initial findings or maybe ongoing progress, but without creating a formal written record just yet.
Okay, like an early update.
Exactly. Information you might include here could be tests that aren't finished, maybe responses to interrogatories.
Interrogatories. Those are the written questions under oath, right?
That's right. Basically a formal written Q&A for gathering evidence. Or you might cover document production or upcoming depositions. They're more fluid, designed for quick exchange, especially early on. And finally, the written reports. These are the formal, official ones, often used as an affidavit or a declaration in court.
Which are those formal, sworn statements used as direct evidence.
Precisely. And because of that, you need meticulous attention to detail. And importantly, you have to be really careful about limiting what you write. Only include what's necessary, what's directly relevant to your findings and your opinion. Nothing extraneous. Now, this brings up an important tactical point. A strategic consideration. To minimize the chance of being deposed early on. It's often smart to avoid producing a full written report for as long as you possibly can.
Really?
Yeah. The longer you can stick to verbal communication, the less you expose yourself and your findings to that early scrutiny, those potential challenges from the other side. It's kind of a strategic move in the legal dance.
That's a really crucial tactical tip.
Yeah.
But doesn't that strategic delay create a risk, like information getting lost or maybe misinterpreted if it's only verbal for too long? How do you balance that?
That's a very fair question. And yeah, it highlights the need for careful management. While avoiding a formal written report early is strategic, it doesn't mean no record keeping at all.
Wow.
You'd still maintain detailed internal notes, document your findings, your communications, very detailed. Verbal reports are usually preliminary updates. The understanding is that a formal, detailed written report will come later, when the findings are more solid, more refined, or, when the legal team decides it's absolutely necessary for a filing or something. It's really about timing and control.
That makes a lot of sense. It's like managed risk. Okay, so knowing the types and the strategic timing, what are the core guidelines for writing reports that can really stand up to scrutiny, especially when we're talking legal challenges, expert testimony? How do you make sure your opinion isn't just stated, but it's like rock solid?
Well, a key technique, especially in testimony, is using hypothetical questions.
Right.
These questions can help guide and support your opinion. They frame your findings within a specific factual context. So an attorney might ask something like, assuming facts X, Y, and Z are true, what's your expert opinion on the source of this malware? Now, it's vital, absolutely vital, that these hypothetical questions are based only on factual evidence that's already been presented or is assumed true for the question. And they should include only those facts that genuinely support your opinion or conclusion. You can't just sneak in new, unproven stuff within the hypothetical. But there's a catch. Hypothetical questions can also be misused.
How so?
They can be made so complex, so convoluted, that the finder of fact, that's usually the judge or the jury deciding the truth, they might struggle to follow it or to really evaluate the answer effectively.
So defeats the purpose.
Exactly. Simplicity and clarity are key, even with hypotheticals. The goal is to clarify, not to confuse. Beyond hypotheticals, there are like 4 foundational pillars of credibility an expert witness has to meet before they can even testify. And these directly influence how you write your report. First, your opinion, your inferences, your conclusions. They must depend on special knowledge, skills, or training. You have to actually be an expert.
Makes sense.
Second, you have to truly qualify as an expert in the field. Your background, your certifications, credentials, they all need to strongly support your expertise. Third, you have to testify to a reasonable degree of certainty. This isn't about being 100% sure all the time, but showing professional confidence in your findings based on accepted methods.
Okay.
And fourth, experts have to know the facts their opinion is based on, and be ready to testify in response to a hypothetical question using those facts. These conditions, they're the bedrock of admissible expert testimony.
Okay, let's pivot now to something you touched on, a particularly sensitive area. You mentioned reports that come with significant risk. What makes these preliminary written reports so sensitive? What are the big dangers professionals need to be really aware of?
Yeah, this is super critical. Every aspiring forensics pro needs to get this. Anything you write down as part of your examination for a report, it's subject to discovery from the opposing attorney.
And discovery is that formal legal process for information gathering before trial, right?
Exactly. Demanding documents, depositions, interrogatories, requests for admissions of fact. So once it's written, it's potentially discoverable. And that means it can be used against you or your client. And that's precisely why written preliminary reports are seen as high-risk documents. They contain sensitive info, maybe incomplete info, and if they're not handled just right, they could create an opening for the other side to discredit you or your findings.
Yikes.
Yeah. Even early thoughts, unconfirmed theories, maybe initial findings you later disprove if they're written down, they can be seized upon, used to argue against your final conclusions or your expertise, and what's worse, destroying a report once you've created it. That can be seen as destroying or concealing evidence. Lawyers call this spoliation, and it carries really gray legal consequences.
Spoliation.
Yeah, it can lead to monetary sanctions, big fines, or even evidentiary sanctions for your client, meaning evidence might get excluded from the trial entirely. You can't just make an unfavorable written preliminary report disappear. So when you do have to write a preliminary report, it should generally include the same info as a verbal report, but with some key additions. You want to summarize your billing so far, estimate the cost to finish the job. Crucially, identify a tentative conclusion, not preliminary. Use tentative.
Tentative, not preliminary.
Yeah.
Why the difference?
Tentative implies it's still subject to more investigation, refinement. It signals it's not the final word. Less definite than preliminary.
Got it.
You also need to clearly identify areas that need further investigation and get confirmation from the attorney on the scope of your ongoing work. Manages expectations, keeps clarity on what's still left to do.
Wow, that really underscores the weight of every single word you put down. So, okay, beyond these inherent risks, what does this all mean for the actual structure and the writing style? How do we ensure findings are crystal clear, impactful? It's not just the content, it's the presentation.
Exactly right. Structure and style are just as critical as the substance itself. A standard report generally follows a clear structure. You'll usually have an abstract or summary right at the beginning, gives the key findings quickly. A table of contents for navigation. Then the main body of the report, that's where your detailed findings and analysis live. A clear conclusion summarizing the definitive findings. References for any external sources you cite. A glossary, which is important for defining technical terms. Acknowledgments, maybe. And appendixes for supporting documents. Now, when it comes to writing quality, you really need to focus on communicative quality. Ask yourself, is this easy to read?
Right.
Are the ideas relevant? Clearly organized? Is the language simple, direct? Is punctuation and spelling accurate, consistent? These might sound basic, but they're foundational for credibility. Your report organization is huge. Lay out ideas logically, build arguments step by step, group related ideas together, and for your writing style, be very deliberate. Avoid jargon, slang, colloquial terms if you can. If you have to use technical terms, define them clearly.
Okay.
Use a natural language style. Don't be overly formal or too casual. Find that professional balance. Avoid repetition, generalizations, vague language. Be precise. Use active voice, not passive voice. It sounds more direct, more authoritative. I found X, not X was found.
Makes sense.
Avoid presenting too many unnecessary details or personal observations. Stick to the facts in your professional analysis. Always project objectivity. Your job is impartial findings, not emotional advocacy. And finally, include signposts. Transition words, phrases that guide the reader, show how ideas connect and flow.
That's a really comprehensive guide to the writing itself.
Hmm.
All right, beyond the words, how should we think about the layout, the overall presentation of these critical reports? Does the visual organization matter just as much?
Oh, absolutely. The visual layout, the presentation, they contribute hugely to professionalism and readability. There are a couple of common layout systems you see. One is the decimal numbering structure that divides things into sections, subsections like 1.0, 1.1, 1.1.1, then 2.0, 2.1, and so on. The numbering restarts for each main section.
Mm-hmm.
The other is legal sequential numbering. This implies more of a continuous hierarchical numbering, often preferred in legal docs for really precise referencing. Other things to think about for layout and presentation. Consistently provide your supporting material. Format everything uniformly. Consistency looks professional. Clearly explain your examination methods, your data collection methods. Include any calculations you performed. Critically, provide for uncertainty and error analysis where it applies. You have to be upfront about limitations.
Right, honesty about what you don't know, too.
Exactly. Thoroughly explain your results and conclusion. Provide accurate references for everything cited, and include those appendixes for raw data, images, logs, anything bulky that backs up your findings. And here's a really fascinating, practical tip for anyone starting out. Whether you end up working for a law firm, a digital forensics firm, a research lab, law enforcement, wherever, these organizations, they already have established formats for reports. They have templates, standards.
So don't reinvent the wheel.
Precisely. The first step isn't just opening a blank document. It's finding out what the existing standards and samples are from your organization or the client.
Yeah.
Always get samples from them before you start writing. It ensures you meet their specific needs, keeps things consistent. It's a massive shortcut to credibility.
That's a total game changer for efficiency and just looking professional right out of the gate. Okay, finally, let's talk tools, the tech side. How do forensic software tools play into actually generating these reports? Are they like a magic bullet, or is there still a big human element?
Forensic software tools are incredibly powerful, no doubt. They automate a lot of the initial data extraction, the heavy lifting. They can generate reports detailing what evidence was found and where it was located in the digital environment. Cataloging files, timestamps, network connections, tons more. Provides a detailed audit trail. Many tools, Autopsy is a common example, can produce really detailed logs of your analysis activities and reports that give you just a wealth of raw findings for a case. However, and this is really the crucial part, it's still the forensics examiner's responsibility to explain the significance of that evidence.
The so what factor.
Exactly. The software tells you what and where. You, the examiner, have to explain why it matters to the case. And, if necessary, you also need to define any limitations, any uncertainty that applies to the findings. Like if a tool couldn't fully recover a corrupted file, you have to state that, can't just ignore it. These software-generated reports, the logs, they usually come out in common formats like text files, Word docs, spreadsheets, HTML. So they're versatile, easy to integrate into your final formal report. But the interpretation, the analysis, the communication, that's still very much on you, the human expert.
What's fascinating there is just how much goes into simply articulating the truth from digital evidence. It really is a skill just as vital as the investigation itself, from understanding what the court needs to strategically building your argument and then presenting it with just impeccable clarity and objectivity. Every step seems designed to make sure findings from the digital world translate meaningfully into the real one, especially the legal world. It's really a process of turning complex, intricate data into understandable, actionable insight. Well, thank you so much for joining us on this deep dive today. We really hope this exploration of forensic report writing has given all of you listening a clearer picture of its complexities and its vital importance in the field. And this does raise an important question for you, our listener. Based on everything we've talked about today, what aspect of forensic report writing do you think will be the most challenging for you? Whether it's in your studies or maybe your future career, and why? Let us know down in the comments. We'd genuinely love to hear your thoughts on this. We really hope you found this deep dive helpful. And if you did, please remember to like, subscribe, follow, share, and comment. It helps support our work, helps us keep bringing you these insights. Today's deep dive into report writing was based entirely on Chapter 14 of Guide to Computer Forensics and Investigations, 6th edition, by Nelson and Stewart. Truly a foundational text if you're serious about this field. As digital evidence keeps evolving, the art of communicating its truth effectively, that's only going to become more essential. How will future reporting standards adapt to things like AI forensics, cloud investigations, emerging cyber threats? It's definitely a question worth pondering as you move forward in your learning and your careers.